This is in the matter of the state of Wisconsin versus Brendan Dassey, case number 06CF88. Appearances, please.
The state appears by Calumet County District Attorney KRATZ, Assistant Attorney General Tom Fallon, Assistant District Attorney Norm Glen, all appearing as special prosecutors.
We are here this afternoon on a motion in Lemon.
Judge, attorneys Mark FREMGEN.
Oh, I'm sorry.
That's fine. We're very forgettable. Attorneys Mark FREMGEN and Raymond Edelstein on behalf of Brendan Dassey, who also appears in person.
You're not forgettable. You just have to be faster.
I'll remember that.
All right. We're here this afternoon on a motion in Lemon brought by the defense seeking ultimately have admitted expert testimony on the statements made by the defendant Brendan Dassey and previously found by this court to be voluntary. Specifically, the defendant seeks to call a clinical psychologist, Dr. Robert Gordon, to offer an opinion on the psychological characteristics of the defendant as well as his age and intellectual development, and whether these factors put him in an increased risk to potentially make a false confession. The defendant has asked the court to permit this testimony. He has done this by making an offer of proof, in this case because of limited availability of the special prosecutor who was trying the Avery matter, and Dr. Gordon, who will be out of the state for several weeks. The defense provided the court and the special prosecutor with a 5-page written report and an approximate 3-hour direct examination of Dr. Gordon on DVD, in which Dr. Gordon discusses the methods he used and the findings he made in this case. Today, the special prosecutor has an opportunity to examine Dr. Gordon. The court will determine whether Dr. Gordon's qualifications, in conjunction with his proposed testimony, will assist the jury in trying this case. Under Wisconsin law, expert testimony is admissible if, number one, the witness is qualified, that is, he is possessed of specialized knowledge, skill training, or education. 2. The witness testimony will assist the trier of the fact. And 3. The testimony is relevant. These preliminary questions of competence and relevancy must be decided by this court. With that said, Mr. KRATZ, you may examine Dr. Gordon.
I do.
Judge, just a few procedural issues.
Sure.
If I may, we did provide to the court and Mr. KRATZ 2 DVDs of our direct or our offer of proof, and we'd ask the court consider or mark those as Exhibits 1 and 2 or Exhibit 1A, 1B for purposes of the record. And then we have, in that DVD, there were some demonstrative exhibits we've condensed to more of a computer-generated exhibit, and Dr. Gordon will be testifying as to those if Mr. KRATZ has questions of those, and he'll bring those to the stand as well. And I suppose we'll mark those as exhibits if need be.
The DVDs will be marked for purposes of the hearing as Exhibits 1 and 2. I'd ask you, Mr. KRATZ, I can't tell you obviously to with any great specificity to limit your examination, but I would hope you could do that within an hour. You may proceed.
Judge, we're the moving party. I suppose I'll move that Dr. Gordon testify at this time, and then we'll waive any further direct at this point.
All right.
Dr. Gordon?
Come up here, Doctor. To be sworn, please.
Please raise your right hand. Please be seated. Please state your name and spell your last name for the record.
Please bear with me just a minute, please. My name is Robert H. Gordon, Gordon.
Dr. Gordon, good afternoon. My name is KRATZ. I'm special prosecutor in this case. Had the pleasure of watching your direct examination on DVD, which, as I understand, was taken sometime in March. I think it was March 12th. Is that your recollection?
I recall it was close to that time. I don't have the exact date, Mr. KRATZ. I could look on my Palm Pilot if you like.
That's fine.
To verify.
I've seen the direct. The first series of questions I have of you, Doctor, is your experience in this particular area. That is, providing testimony regarding suggestibility or vulnerability to suggestibility. Let me ask you, in the state of Wisconsin, how many occasions have you testified in a trial setting, that is before either a judge or a jury in a trial, as to this particular issue, that is, vulnerability to suggestibility?
In a trial or an offer of proof as well?
I think, was my question not clear?
No.
I asked in a trial, how many times have you testified?
One time. Well, one time to be exact. There may be more. I don't keep record of that. I should.
Well, if it was more than one, would that be something that you'd remember?
Probably not, considering the number of cases I see in a given year. And I've been doing this since 1976.
You've been testifying about suggestibility since 1976?
No, that I cannot say. Probably since 1985, 1995. I really can't say counsel with any.
So, sometime within that 10-year period, you've been testifying about suggestibility. Is that your testimony?
Sometime within that period of time, I have testified once in a trial. I have conducted evaluations and also attended in presentations and given presentations regarding this. That's very much true.
Okay. Do you remember in which county that testimony occurred in?
I don't know the name of the county. I know the city was Wausau. I think that's Marathon County, if I'm not mistaken.
It is. Are you aware, Dr. Gordon, of and I think in your direct you talked about the limitations on your opinions that you offer. That wasn't very artfully asked. Let me try again. Let's start with what you are not offering opinions on. As I understand that you are unable or unwilling to offer an opinion as to whether any statement, in this case, the statement by Mr. Dassey, was true or whether it was not true. Is that correct?
That's very correct. It would be unethical for me to do that, and I would just seriously doubt whether the judge would even let me do that, even if I chose to do that.
Do you know the reason for that? I mean, I understand that you have forensic background, meaning the intersection of the field of psychology with that of law. Do you know why you weren't allowed to testify or comment on the credibility of any other witness?
I'm not a human lie detector, and I don't invade the province of the trier of fact, but they need to consider very weighty questions regardless of whether it's this matter or a fitness trial or NGI or whatever the case may be.
All right. You indicated in your direct examination that you performed a battery of tests pointing you to the ultimate conclusion that Mr. Dassey was substantially more vulnerable to suggestibility. Do I understand your opinion to that was your opinion?
That was one of my opinions, yes.
The other opinion had to do with the, or taking the next step or the next leap, if you will, that somehow necessarily means that Mr. Dassey is also more prone or more apt to giving a false confession rather than just a confession. Was that also your opinion?
He's more apt to give a confession. If one's more apt to give a confession, it's therefore more likely to give true confessions as well as false confessions.
And that brings me to the point of why you might be asked to testify and what the jury might gain from your testimony. You understand that you'll only be allowed in this case to testify if you actually add something to the equation. That is, if you assist the trier of fact. You understand that?
My role would be to make a confusing matter less confusing. And if I'm not able to do that, then my role is not in this chair.
All right. And so, if your opinion, and let me just ask you, is your opinion that Brendan was more susceptible or more vulnerable to making any kind of confession in this case, given the constellation of not only his IQ, but his personality traits?
Not to quibble, Mr. KRATZ, but I think I said he is very suggestible to do that. I use the word very in quotation marks. That's the modifier.
I'm talking about confessions. Are you suggesting that Brendan is more suggestible or more vulnerable? You also use the word vulnerable to providing any confession to a law enforcement official.
True.
And whether that confession is a true confession or whether that confession is a false confession, I believe you've already conceded is best decided, in fact, legally decided by the trier of fact, by the jury.
I need to correct your cue, your statement. I didn't concede anything. I'm not here to concede. I'm not here to advocate. I'm here to tell what I believe to be the truth based on my evaluation and training. So maybe...
Okay, what?
If you could restate...
Here, one at a time.
I'd ask that he answer the question, Judge. If there's a problem with that, we can...
Dr. Gordon, you're starting to get somewhat argumentative in that answer. Just answer the question that is asked of you.
May I have the question read back, please?
Sure.
I'm sorry, I don't hear the question.
I'll ask it one more time. Is it your opinion that Brendan Dassey was more vulnerable than the average person to providing a confession to law enforcement officials?
Yes, sir.
Before performing or at least before, I understand that the Gudjonsson suggestibility scale was the last test that you spoke of, but before administration of that test of Brendan, were you able to predict those results? That is, by knowing Brendan's IQ and personality characteristics, were the results of that test predictive for you?
There's a correlation with those other factors. So if I asked to speculate about what his scores on the Gudjonsson scale would be, I could speculate, but because there's a correlation, but it's not a one-to-one correlation, so that everyone has a low IQ, everyone has a certain personality characteristics, automatically scores a certain way on the Gudjonsson scale. That's not true. And so, but I would have some hypothesis.
Okay. We'll get to the Gudjonsson in just a minute. But let's talk about a person's actual ability to resist suggestion. Would you agree, Doctor, that an individual's observed ability to resist suggestion would be a better measuring tool or better measuring stick than the Johnson or any of your other psychological testing you use in this case?
Well, I'm not in a position to say what is necessarily better. There are just different tools and different. It's important to rely on data from a variety of sources, and objective testing is helpful because there are objective norms and standards that you can compare to a person. But it's important also to obtain observed data, interview data, collateral data. So I could compare it to going fishing. I mean, it's good to take live bait. It's good to take artificial lures. And it's not just to rely on one or the other because you never know about the day.
Well, the problem with the fishing analogy in this case is the jury's going to see Brendan's actual interaction with the police. Isn't that true?
That's I don't know that that's my understanding would be the case.
Correct. That's something that you looked at. That was one of the factors that you considered in forming your ultimate opinion. Is that true?
That's true.
Are you aware, Doctor, that in this case, not from some test results, but in this case, on a number of occasions, Brendan was able to resist suggestions by law enforcement officers when involved in his interrogation?
Yes.
Is it your opinion that you consider those instances of where Brendan resisted those efforts by law enforcement?
Yes, sir.
Another factor that you considered, or at least in your direct examination, you indicated that you considered, was Brendan's recantation. That is, that sometime after his admission or his statement of culpability, he recanted that statement. Is that a fair characterization of his testimony?
I believe so, yes.
Could you explain why it is that a recantation or a retraction of a confession is an important consideration for you?
It's an important consideration in that there's a correlation between coerced confessions and the length of time that the recantation took place. The sooner the recantation, it's correlated with, the research shows it's correlated with more likelihood that there was a coerced confession.
Right. And that's where we need to go back to your opinion. Are you now offering an opinion that this was a coerced confession? You've used that term.
No, that's not for me to decide. I'm talking about the defendant's psychological vulnerability and the likelihood that he was suggestible and offered such a statement. So it's a factor that I considered.
Well, it's a factor if we assume or if we presuppose that this was a coerced confession. If it wasn't a coerced confession, recantation really doesn't factor in. Isn't that true?
True.
So assuming, or if we can get a judge or a jury to assume that this was a coerced confession, then your placing weight on the recantation would have some meaning. Is that right?
Yes, sir.
All right.
I'm sorry. I thought you were done with the question.
Are you? No, I was. Thank you. Are you aware of the circumstances under which Brendan retracted or recanted his admission or confession?
I don't recall at the present time.
Do you even know if that was his idea or if it was the idea of another family member that he change his story or change it back to his original statement?
I would be speculating, although I about the dynamics that led to his recantation. If that was he recanted it, and whether it was false or true, and I know that there was family influence.
Well, would that be an important consideration? Would it be important for you to know if it was somebody else's idea, or if the genesis of that retraction or recantation was from somebody other than the subject who was involved in the interrogation?
Well, it would be important to know, because then I would have a better idea of whether it was the defendant making the recantation. But it would also be important because then it would further provide support to the conclusion that he would be suggestible to other people's influence as well.
I see. So either way, it really supports your opinion then, right?
It's a wash either way.
I see. Are you offering an opinion on and we may be quibbling about terms here, but I need to know if this is your opinion on what's called the reliability of Brendan's statements to law enforcement officials.
No, I'm not offering an opinion about that.
Are you offering an opinion on whether Brendan's statements ought to be believed by anybody, whether it's the judge or the jury?
Absolutely not. And that's even contained in the first page of my report to Mr. FREMGEN, dated November 15, 2006.
I didn't see the word ought to be believed.
Oh, okay. It's implied then. Sorry, it just clarifies my role.
Let me just read you then, Mr. FREMGEN's. And so you don't feel like you're being tricked or set up, I'm going to quote from Mr. FREMGEN's offer to this court. Dr. Gordon is expected to testify that based upon the evaluation of the defendant, the evaluator's specialized knowledge in the area of psychology of confessions, and his review of relevant research in this regard, that Brendan Dassey's statements to law enforcement are, quote, not reliable, and that they are the product of significant suggestibility.
They might not.
Just so we're sure.
They might.
You've indicated that is not your opinion. Is that correct?
That's not exactly my opinion.
The decision or the differences between admissibility of a statement, that is, whether they should be considered by a jury, you understand as a function of the court. That is, the court gets to decide whether or not a statement is, in fact, admissible.
That's why we're having this hearing. And he will make the decision, yes.
Well, the decision on admissibility has already been made. Did you know that?
I did. The suppression hearing took place, and there was a motion to have another suppression, and that was denied.
Okay. So what makes you think that this hearing is about whether this statement is admissible or not?
That was my error. I beg your pardon.
All right. So you understand now that that's already been decided?
Yes.
And usually the issues of coercion or suggestibility or improper influence or vulnerability go to the issues of whether a jury should hear the statement in the first instance. That is, it goes to the issues of admissibility, not the weight or the trustworthiness of the statements.
Judge, I object. I don't think that's necessarily accurate based upon Jury Instruction 180, which deals with the jury's right to decide whether to believe a statement in whole or in part. And how they come about and get to that point, I think, is up to the jury.
Stating the objection also that it seems to me there's a foundational objection to. That was a compound, beyond compound question. We're talking about correction and vulnerability and too many things, so objection is sustained.
All right, I can I can certainly break that into separate components. The decision of whether a statement is coercive to the point of being unlawfully so is a decision for the court. You understand that?
Yes.
And the trustworthiness or the reliability or whether a statement ought to be believed, do you agree is a function for the jury to consider?
It's a function of the judge at the time of a motion to suppress, and at a time of a trial, it's a decision of the jury.
All right. Then, I guess, we've come full circle, Doctor. Understanding that reliability is a decision for the jury and something that you're not willing to offer an opinion on. And understanding that admissibility is a decision for the court, how is it that you believe that you can assist this jury in the consideration of a fact at issue? That is, how are you going to help this jury yourself?
Well, the way it was stated by Mr. FREMGEN, when you talk about the reliability, painted it in a very black and white terms. I'm here to talk about scientific ways to evaluate a person's psychological vulnerability to respond to leading questions or to respond to external pressure. I'm not an expert regarding police interrogation. It would be a Dr. Richard Leo, attorney, social psychologist, and sociologist at the University of California in San Francisco. He would be much more in a position to talk about external factors. I'm here to talk to you or to the court or whoever might want to listen about what psychological test, what history, what research, and what a person's social history has to do with the likelihood that they will be suggestible.
I appreciate your answer. The question, though, was how is that going to help the jury? How does that help them decide part of this case? What are you helping them decide?
I would help them decide on how much weight to place on Brendan Dassey's confession. They might decide if they find me an incredible witness to place 100% weight on his confession, or if they think that the information I provide is probative, not prejudicial, assist them, then they might decide to be more cautious in totally or partially accepting his testimony. That's their job.
If allowed to testify in this trial, Doctor, we will undoubtedly go through the Wechsler, the 16 PF, and in great extent the MMPI. But for today, I'm going to limit my questions to the Johnson suggestibility scale, as that appears to be what you call the best measure or best objective test on the issue of suggestibility. You still hold that opinion, I assume.
As long as it's understood that it's one component of a comprehensive evaluation.
I do. And see, then, in your direct examination, you talked about IQ and personality characteristics as well. And I think
those are very crucial as well.
And Mr. Johnson, I think, suggests or mandates the same as well. The administration of the Johnson scale, the GSS, we'll call it for short, as I understand, is intended to mimic a police interrogation. Is that fair?
That's barely fair. It's a very simplifying it very much.
All right.
But
I'm sure you're going to.
So we can facilitate the discussion and have it flow. I'll say yes.
Why don't you explain as best you can how this particular test is designed to replicate or to mimic a police interrogation?
I'll be glad to do that. An individual is presented a battery of tests so they don't realize their suggestibility is being tested at that particular point in time. The test is presented as a memory test, and they're told that I'm going to read you a story. This is paraphrasing. I could pull out the manual and give you the exact instructions, but...
Would you mind terribly if I interrupted you as we go along? Is there anything about a police interrogation where a subject is told that this is a memory test and not an interrogation?
I don't believe that. They might be told different things, but I don't think they're told that.
All right. I'm trying to see the similarity, but maybe you can point to those things that are meant to be,
well,
similar to an interrogation. I know how the test works. I've seen your direct. You don't need to go through all that.
Okay.
Just how is it similar to an interrogation?
It's similar in that a person is told a criminal act that allegedly has taken place and the outcome and details. And then they are asked to first report their recollection of what they've been read. Let
me stop you there. In your direct examination, you omitted that part of the results. That is the recitation or the memory part of it. Tell me how. All you can remember, I think, is probably what Gajonson suggests you ask about the story. How did Brendan do on that part of the test, since we never heard about that on direct examination?
I did not score that. I recorded his responses in order to administer the test in a way that was in a standard administration. Those scores are not used. The reporting is not used to obtain quantifiable information designed to assess for the suggestibility part.
So, the ability to accurately recount the story or specific facts of the story really isn't something that is scored. At least it isn't scored on where there's norms or where you're able to assign some percentiles. Is that correct?
True.
Okay. As I understand then, after that occurs, the first series of, well, I apologize. Let me go back. The kind of memory, and I assume that you know about memory and how it works and different kinds of memory. Do you know what kind of memory it's called, where you parrot back or recall a story that's been read to you?
Well, one that comes to mind, immediately to mind, there may be others, is recall or short or very short-term memory.
Have you ever heard of the term semantic memory?
No.
Do you know the differences between semantic memory or autobiographical or event kinds of memory?
No.
Let me ask you, Dr. Gordon, if a person is asked to remember or recall or describe something that's read to them, do they remember that differently than an event which they actually lived through?
Yes.
Do you know individuals with Brendan's particular intellectual difficulties, whether they are significantly better able to recall events that they've actually lived through rather than something that's read to them or book kind of learning?
All of us would be able to better remember, unless we're severely traumatized, events that we've been through. But especially a person who has limited intellectual functioning, then they might be able to better concentrate, better remember things that they experience in a multi-sensual, very senses the way than if they simply heard something read to them.
Well, let me just ask you if you're aware of studies that suggest that especially individuals with intellectual difficulties, that they are much, much better at event kinds of memory. That is, they have higher accuracy, less tendency to acquiesce, and then the semantic or this other kind of memory that you've described after hearing a story. Understand my question?
Yes.
Are you aware of those studies?
I'm not aware of the studies, but based on my knowledge of the area, that would not surprise me.
It makes sense.
Sure.
And so the replication or mimicking an interrogation, would you agree that, especially in an individual with intellectual difficulties, that they might be expected to recall in more detail, to be more accurate and, in fact, less susceptible to suggestibility with something that they've lived through rather than a story that's read to them?
If you only consider that factor and not their limited intellectual functioning and limited memory, then the answer would be yes.
All right. By the way, the raw scores and everything that you've testified to or about here today, had you heard of or did you comply with the state's demand or request for that raw data with the information?
I was made aware of the request this morning.
Okay. Is that something you can comply with before trial?
Before trial, but under limited conditions, I purchased these instruments with written agreements that I would not disseminate that information to anyone other than psychologists or to psychiatrists for the Gudjonsson inventory that don't have the training in the eyes of the publisher or the developer to have adequate understanding of the ways to interpret those results. And so I would be violating what I signed and violating my ethics as a psychologist to reveal the raw data to you. If, on the other hand, and this is how I've handled this before on many occasions, if you had a psychologist retained by you, I could send the psychologist my entire file without exception.
That information is just inappropriate or too dangerous in my hands. Is that what you're saying?
I don't like to say too dangerous. It might just be misused, misunderstood, not doubt due to any intention on your part.
I would ask you questions based upon your raw data. You understand that, right?
I understand.
I would ask you questions based upon the notes that you took. You understand that?
You can. Let me clarify. My notes are yours to have.
All right.
But I'm talking about the test reports. The test answer sheets. Test questions. That is what I cannot share with you. I can share everything else with you, but not that.
That brings me to another question. Did you videotape the administration of the Gudjonsson suggestibility scale?
No.
Can you tell us why?
Well, I've testified probably, I don't know. You can, please don't impeach me if I get the wrong number from any direct. I've probably testified 1,000 times or so, and I've done thousands of evaluations of different sorts, and it's not common practice at all to videotape those evaluations. And actually, it would be a deviation from standardized practice to do so. And I operate according to a certain protocol, and I try my best to have an objective evaluation that is fair, straightforward, honest, and the results based on the objective ways of conducting an evaluation. Am I distorted if that recording was, if it was raw, if it was going? I've had attorneys ask to sit in. I'll say, if you need to sit in, then I won't do the evaluation. I can respect your need to do that, but that's not how it's done.
In this case, you got a chance to watch the investigators ask coercive or interrogation kind of questions. Isn't that right?
I had a chance to.
I'm sorry. Go ahead.
I had a chance to watch them interrogate Brendan Dassey.
Right.
It's whether they were coercive. Depends on the particular question.
You understand that the reason, at least in Wisconsin, that courts and in fact the legislature has mandated or required police officers to videotape those kinds of interrogations. And so it removes any question about how those questions might have been asked or what influences might have been placed upon the subject of that. You understand that?
Judge, I'd object to that question. I don't know if there's been any foundation that this witness knows that that's the law in Wisconsin and whether this witness is aware of the Young case. And I'm not even sure it's necessarily relevant for the purposes of this issue about the admissibility or the offer of proof to allow for this person to testify at trial.
I'm going to sustain the objection. There really hasn't been foundation laid for that. I do have some relevance concerns. If you want to try to lay a foundation and ask if okay.
I can certainly wait for trial to do that, Judge. I think you expect us to believe you as to what the answers were. That's the bottom line, isn't it?
Your job is to question me. My job is to try to be objective as far as possible. But whether you believe me, that your job is not to believe me. Your job is to question me. Your job is to cross-examine me.
You'd like this court to believe that those were the answers that Brendan gave. Is that right? Without the benefit of either the raw results or a videotape or something else?
My hope is that my testimony would help the trier of fact make appropriate decisions and render the justice in this case.
Okay. Let's go to the second part of the GSS, where the subject is provided with many times leading questions. In fact, most of the 25 questions, as I understand, are leading questions. Is that true?
That's not true. There are 20 questions total.
20. You said 25 in direct. I'm sorry. There's 20 total?
All right. I beg your pardon. Well, there are 20 total. My error.
Okay. And of the 20 questions, most of them are leading. Is that right?
3/4, yes.
And they're meant to gauge whether or not a subject is willing to acquiesce or to yield to a particular alternative or to a particular question. Is that true?
Yes. They measure the extent which an individual yields to leading questions.
Importantly, Doctor, within this test, and perhaps you can correct me, most of the questions that are presented are what are called false alternative leading questions. Is that true?
I believe there are false alternative leading questions, but they are not the majority. I could come up with a number if you'd like.
Well, no. We're going to probably get a more detailed summary at some point. But this methodology mandates that the questions don't really have a true answer. In other words, it's a question like, did the lady have a red hat or a blue hat when she may not have had a hat at all? Isn't that fair?
That's fair. That's one type of question on there. That's true.
All right. How is this test then similar, or that part of the test? How is it similar? How does it replicate, or how does it mimic a police interrogation?
It would mimic a police interrogation if a leading questions were asked.
Leading false questions, right?
Leading
false alternative questions?
Leading false questions, or leading true questions, or leading false alternative questions.
Really? So, if a subject answers correctly when a true answer is provided, do they get a point for yielding?
I want to make sure I have your question.
If a leading question is provided to a subject in the GSS, and if one of the answers is a correct or a true answer, and the individual correctly answers that leading question, are they provided a point for yielding?
That wouldn't be a leading question if they're asked an accurate question.
Really?
There are 5 of 20 questions that are not yielding.
That are not leading?
I mean, not leading.
If I ask you, my shirt's blue, isn't it? That's a leading question, isn't it?
It is.
And it contains a true statement. In other words, if you answered yes, you'd be answering my leading question. Isn't that
true?
True.
True.
If Brendan or anybody else who takes this test answers a leading question that has the correct answer in it, truthfully or correctly, do they get a point for yielding?
No.
When a police officer then asks an individual, asks the suspect, whether or not they did a certain act or whether or not they involved themselves in a crime, even if it was in a leading way, how does that then replicate or mimic the GSS?
It would be similar to your blue shirt, and they would not get a point. It would be not leading according to Johnson's definition. But I could see why you're calling it leading. And they would not get a point on the Johnson test, and that they would not be seen as trying to influence the subject.
Which brings me to my point then. The import of the Johnson leading question are that they contain false answers or false alternatives. That's true, isn't it?
That's true.
All right. And so the assumption that has to be made, at least the assumption, if this is to be given any validity, is that the police officers in an interrogation that this was meant to mimic also have to have provided false alternatives or false suggestions. Is that true?
That's why when you said, does it mimic, I said that's simplifying it. So that's true. I mean, what you said is true. It doesn't totally mimic a police interrogation.
By the way, I'm jumping ahead, but I'm doing it for a point. The results or the opinions that are able to be drawn from the GSS scores include whether an individual is vulnerable to making a false confession. Is that true?
That's true.
Okay. Doctor, are you aware of any problems with the methodology of suggesting the very result within a question and then that leading to an ultimate conclusion? Do you understand my question?
It's confirmatory bias.
Right. And in fact, the GSS, you're providing a subject with a false statement that if they adopt, you're then able to find that the person is vulnerable to making false statements, false confession. Is that true?
Compared to the norms on which the test is based, yes.
And are you aware of whether the GSS has been criticized for that very methodology?
No.
The next part of the test that, again, correct me if I'm wrong, is meant to mimic or replicate an interrogation is use of mild coercion. In fact, it's a statement of disappointment or a statement of condemnation as to previous answers that were given. Is that true?
Everything but the word condemnation. I think that might be too strong.
All right. Something akin to folding your arms, telling Brendan or whoever the subject is that I'm disappointed in your answer. I think you can do better, and suggest that they try harder this time. And then they're asked the same series of questions. Is that basically it?
Yes, you made a number of errors. It is therefore necessary to go through the questions once more, and this time have you try more accurate to be more accurate. So it's not as harsh as you state, but it does nonetheless expressed the belief that they could do better next time.
All right. And this series of observations that you make, then, if, in fact, the subject follows your suggestion and then changes their answer, which is really what it is then counted as what's called a shift. Is that right?
True.
This shift norm, or the normal score, or the score of that population which was administered this test, as I understand, is 2 or something just above 2. Is that right?
That is correct for adult populations. And Brendan he's still adolescent, but we're talking about adult court. So different norms could be used, could be debated that adolescent norms might be more appropriate.
And that population against which Brendan was compared, that norm, if you would, do you know what the backgrounds of those individuals, or generally what kind of people were used to establish those norms?
Yes.
Were any of them incarcerated for first-degree murder? In other words, was this test administered to anybody while in jail for first-degree intentional homicide?
I don't know. I'd have to check the manual.
Let me ask you, Dr. Gordon, before administering this test to Brendan, did you tell him that you were working on his behalf? That is, that you were a defense expert?
No.
Did he know who you were before you sat down and spoke with him?
Yes.
How do you know that?
Oh, did he know in advance?
Yes.
I don't know. Sometimes, in this particular case, sometimes attorneys tell their clients that I'll be coming, and sometimes they don't tell them. Or maybe even if they're told, they don't remember. So I don't know.
I guess what I'm getting at is, how did you introduce yourself, and how did Brendan know why you were there to speak with him that day?
I told him I was there to, at the request of his attorneys, to do a psychological evaluation without specific regard to suggestibility, was not mentioned.
I understand that. My point is, you had identified yourself with being aligned with the defense team, there on behalf of his defense attorney.
No, if you let me finish, I could clarify that.
Judge, I'd object anyways. I don't know if it's, again, relevant for purposes of today's hearing to determine the admissibility or the use of an expert at test to testify in this particular area. I understand that it might go to weight and how the weight would be, how the testimony would be considered by the trier of fact. But that's not the issue. The issue is whether the trier of fact should even be allowed to hear that. Weigh this up to the trier of fact. We should leave that up to them.
Yeah, I will overrule that objection. And I think this threshold question can be asked. Beyond this, no. Go ahead. You may answer if you remember the question.
I don't, Your Honor. I'm sorry.
Can you re-ask that, Mr. KRATZ?
Sure.
Please.
I think you were explaining how you identified yourself and why it was that you were there to see Brendan.
I explained my purpose of being there with Brendan as no different than I do at any other time. I explained who requested that I do the evaluation, that I'm there to do an evaluation. Sometimes, if it's for fitness or some specific reason, that I might tell them. But in regards to suggestibility, that I don't tell them specifically. I tell them that I'm going to do an overall evaluation at the request of their attorney, that they don't have to answer questions if they don't choose to, that I do a fair and objective evaluation to test the best of my ability. I cannot guarantee the results. If the results are not pleasing or consistent with their case in the eyes of their attorney, they don't have to be used. And then I talk to them and try to see if they understand my explanation. If they don't, then I try to explain some more. I'll tell them that I might be retained by their attorney, I might be paid by their attorney, but I'm there to do an objective, fair, straightforward assessment. And my assessment might be a waste of their money.
All right. As I understand it, the subject the subject of the test changes their answer. They're given a point, if you will, for a shift for changing that answer. Is that right?
True.
What if they change their answer to what would otherwise be the correct answer? That is, if they said at first that the lady had a red hat on, and then later, as I gave in my previous example, tells you the lady didn't have any hat on, does he still get a point for shifting?
Regardless if he shifts from a correct to false or false to correct, he gets the point for shifting.
All right, yeah. In real life, which is really why we're here, what is that trying to mimic? In other words, shifting from an incorrect answer and then giving a correct answer, why would that be considered something of a negative or going to suggestibility or getting a shift score?
Because I'm not here to evaluate whether a person's telling the truth or not. I'm evaluating whether they are susceptible to suggestibility. That is also measured by yielding and shifting their responses.
In the real world, if a subject of an interrogation denies a fact or denies an involvement, and let's assume for this question that they did that. That's a true thing that they've been asked about. And they said, no, I didn't do that. Officers ask them again, or maybe even provides them with some evidence that they were involved in that. And the person shifts to the correct answer or admits that they did it. Would that be an example, at least with the GSS, of being a shift?
It would.
Being suggestible?
It could. It depends on also whether the information supplied by the police officer to the individual is accurate and is known.
Right. I've asked you to assume that, but that would still be a shift, wouldn't it?
It would.
In the GSS?
It would, sorry.
All right. So, the ability to measure someone's vulnerability to suggestibility, at least by this instrument, is not any comment upon the truthfulness or falsehood of that statement. Is that correct?
That's true.
We've come full circle again. How then does this instrument allow you or anybody else to indicate that a person is more vulnerable to giving a false confession rather than any kind of confession?
They're more vulnerable to giving a confession, including false confession. Also, a true confession if they have increased scores on Johnson. Your point's well taken.
Any additional questions, counsel?
Just one area, Judge. Dr. Gordon, your experience with the administration of the GSS, does it include individual, or has it ever included individual who have been charged with first-degree intentional homicide?
No.
For purposes, then, Judge, of the offer of proof and for purposes that we will be including in our memorandum of law to the court, that's all the questions I have of this doctor. Thank you.
All right.
I'd like to redirect on a few if the court will allow me. Just limited. I'll limit to 6 questions, Judge.
I'm going to hold you to that.
That's fine. I accept that. Doctor, you were asked a number of questions about the Gudjonsson scale of suggestibility, correct?
Correct.
Is that the only tool that you would employ in order to get an accurate assessment of a subject for purposes of suggestibility?
Absolutely not.
The other tests themselves that you conducted, were those conducted in an effort to obtain a more comprehensive assessment?
Yes.
And is there a purpose conducting more than one test in order to assess a person's vulnerability to suggestion?
Yes.
What is that purpose?
Well, the different tests I have administered measure different psychological factors in terms of a person's intellectual and emotional functioning. And so if I just relied on one test, then I might not be measuring their intellectual functioning. Or if I just focused on a couple of tests, I might just focus on their intellectual functioning and not their personality characteristics or their suggestibility scale.
So hypothetically, if one had scores that were high scores on GSS, but yet had test results that indicated that they are socially apt and have high IQ, maybe high functioning, would that then lead you to a different conclusion using the GSS?
It very well would lead me to different conclusions. That's a hypothetical. I would still need to consider the entire evaluation. I can tell you that there's a correlation between the GSS, the personality scores from the tests that I used, as well as IQ scores, as well as criminal behavior, as well as age, etc. There's a correlation, but the correlation, again, like I said on Director Mr. KRATZ, is not a one-to-one. So there could be exceptions to that rule. That's a long answer. I'm sorry, Judge.
Last question then to kind of wrap this up. So essentially, you're attempting to obtain sufficient data to assess all of the psychological factors in the psychological environment that affects a subject's potential vulnerability to suggestibility.
With a limited amount of time and limited resources. Yes.
Okay. Thank you very much.
All right. You may step down.
Thank you, Your Honor.
Before Dr. Gordon leaves, Judge, I'm going to renew my demand for Dr. Gordon's file, despite Dr. Gordon's apprehension regarding release of that information.
You may step down.
If, in fact, the court does allow Dr. Gordon to testify, the state certainly is entitled to discovery, which includes a file, those raw materials, notes, and whatever other information may be contained in that file. I appreciate Dr. Gordon's assured that I will be sharing it with somebody other than myself. Again, this is only if the court allows that, and perhaps the court can issue a ruling at a later time, but at the very least, would ask the court, order Dr. Gordon not to destroy or discard anything that may currently be in his file, so that if, in fact, the court provides a favorable ruling to the state, at some point, we are able to get all that raw material.
The court will so order. Dr. Gordon, you heard that, did you not? You are not to destroy any of the notes or materials that compromise this file. By this file, I mean the complete file on the interview and testing of the defendant.
I would never do that, Your Honor, in any case, unless it was over 7 years old, or whatever the statutory requirement permits.
All right. The court has scheduled April 5th at 9 a.m. as a time to hear the remaining motions. The counsel are aware that they have until April 2nd to, if they intend to have briefs their positions to get briefed into court. I ask each of them to prepare a proposed order reflecting their position based on the testimony here, as well as the DVDs and the applicable case law. At the time the court on April 5th, the court, in considering other motions, will announce a decision on this one as well. Anything else, gentlemen?
Not for today. Thank you, Judge.
All right. Can I see you?
Exhibits 1 and 2, do you have those?
I do.
Are they received then?
They are received with the caveat. Exhibit 2. The second DVD appears not to work all the way through. I trust counsel has no objection to me submitting a workable one.
That's fine. If Mr. KRATZ has no objection, I'll send you my second.
All right.
Mr. Edelstein has a copy already.
Very good. See counsel in chambers for a brief meeting.
Thank you, Judge.
Thanks.
We adjourn.